Hello again. Welcome to the New York Employment Law Show. This is episode 5. I'm Scott Peterson from Durazio Peterson LLP, and the purpose of this show is to provide you with information and answers to common questions relating to illegal employment actions and employment discrimination in New York, and to help you navigate the process of handling employment problems, which can often be complicated and complex. So today in episode 5, we're going to talk about what kind of damages you might be entitled to in the event of employment discrimination or sexual harassment. Now, the laws governing employment discrimination, family medical leave discrimination, and sexual harassment differ between federal laws and state laws. Each of these set of laws provides a different element of damages to a successful plaintiff. So if you have a successful claim for sexual harassment, for example, your damages may include things such as damages for the emotional distress that you've endured as a result of the sexual harassment. There are generally two types of those kind of damages. There are what are known as garden variety damages, which mean the sort of ordinary damages that a person might be expected to encounter through a difficult time. And then there are more specific types of damages where you have sought and received treatment from a psychologist, counselor, or some kind of medical provider for the distress that you've been dealing with, the anxiety, the stress, as a result of the conduct. And when you've been receiving treatment, generally speaking, courts have determined that you are entitled to a larger amount of money from a jury. So that's one part. You also are entitled to lost wages in two ways. You're entitled to lost wages from the date that you were fired or that you had to resign because the situation was just too hostile, up until the date of the settlement or the trial or the jury verdict. And then you are potentially entitled to damages into the future. That's called front pay. And that is based upon an assessment of whether you have a new job, what the prospects of a new job are, whether you've looked for a new job. And all of those things are kind of calculated and factored into the determination of what you might be entitled to for front pay. So to use an example, if you were fired under circumstances that gave rise to a claim of sexual harassment, and you were making $50,000 a year, and you've been out of work for a year, your back wages would be $50,000. If you've made lots of different attempts but have been unable to secure a new job, you might be entitled to 1 or 2 or more years of lost wages at a similar rate. If you have found a new job but you're only now making $30,000, you may be entitled to an award of the difference between the two, so $20,000 a year for some duration into the future. You'd also be entitled to have, in most cases, your attorney's fees paid. That means that the attorney who has maybe been billing either by the hour or on some form of a contingency fee is entitled to put in an application to have the fees covered by the defense. And that typically only occurs in situations where there's actually a jury trial. But that's another potential element of damages. The other potential element of damages is what's known as punitive damages. Now, punitive damages are meant to punish the wrongdoer. And you read a lot about or hear a lot about punitive damages, but the reality is that they're not really awarded that often. It's a very discretionary element of damages, and it's typically left to the judge to make a determination as to whether the conduct was so egregious, so bad, as to warrant an award of damages punishing the wrongdoer. The other thing to keep in mind is that if you worked for a municipality or the state, generally speaking, punitive damages aren't recoverable against those entities, so that might not even be an option at all. Other cases have different elements of damages which are also recoverable. For example, the Family and Medical Leave Act, you may be able to recover what are known as liquidated damages or double damages. So if you have an award of $50,000 in lost wages, you may be able to double that and make it $100,000 simply because the law allows for that. So different statutes have different elements of recoverable damages. Again, it varies based upon whether the claims arise under federal law, state law, or both. And a lot of that will depend upon the size of your employer. But these are some of the issues that kind of go into the consideration of whether it makes sense to pursue a lawsuit or what type of legal proceeding you may want to pursue, which is all telling you that it's very important that if you're going to work with an attorney following an employment discrimination or sexual harassment matter, you work with someone who has experience. Whether it's us or someone else, it's really important that you work with someone who has done this before, who knows the ins and outs of this very complex system. So hopefully this has answered some of your questions today. If you have more questions, please reach out to us. We're happy to help. And thanks for watching. Until next time.